This is 21 CF 274, State of Wisconsin versus Ranon Brownlee. I'm Commissioner Evans. Appearances, please.
Your Honor, state appears by Mike Gravely of the District Attorney's Office. The parents of the deceased victim in this case, I believe Kenneth and Carolyn Brown, are also appearing by Zoom today.
All right, Mr. Brown, would you just wave for me? I want to make sure I see you. There you go. Thank you. All right. All right. Counsel?
Ranon Brownlee appears via Zoom, as does Attorney Brian Rolfe, making a special appearance in his behalf. We've received a copy of the criminal complaint. Mr. Brownlee is aware of the associated charges and maximum penalties and waives its reading at this time, and we would request a preliminary hearing date at this time as well.
Thank you. All right, we'll go ahead and set that. All right, Mr. Gravely, what's the state's position on bond? I've had an opportunity to review the criminal complaint, so I am familiar with it, but go ahead.
Your Honor, I believe that yesterday the court set bond at $1 million cash. I would ask that continue today based on the now charged allegations. The court is aware the defendant is a convicted felon based on a conviction, I believe, from 1993. He has 7 priors over the last 30 years, although he has, I believe, no priors since 2000. Has some prior domestic incidences where victims have recanted and the cases have not resulted in criminal prosecution. He's been placed on probation 3 separate times, received a 6-month jail sentence on one of those 7 priors that I mentioned. Again, they are dated priors, but they are significant in number. The allegations here, as the court indicated, you had read it, have a couple of things that are of particular concern. One is that this is a violent, deadly attack that occurs with numerous children present. So this is not an individual, per these allegations, who can control his actions even in the presence of children, including his own children who are nearby, as well as the fact that the much of the violent attack and certainly the parts of the attack that appear to be the deadly portions of this attack but seem to occur after the victim begins to call and is calling 911. So that deterrence for so many of our offenders in no way deterred this particular set of violent attacks. When the court considers strength of evidence in this case, the defendant has admitted that after 911 was called, he both discharged a weapon towards the victim and stabbed her. So those, of course, are the courses are the sources of the deadly instrumentation of death in this case. So from the state's perspective, the evidence in this case is very strong. This is a violent, horrific attack and with children playing out in the yard nearby and a number of young minor children present. So from the state's perspective, in all respects, both in terms of any ability to protect the community and what Mr. Brownlee would do if released, the state believes that significant cash bond is appropriate. I'd ask Your Honor for no contact with the family of Sharnice Brown, including the parents who are on today, as well as the 6 children who are present. I have their initials and dates of birth if the court wishes me to give those to you. And I'm asking for no weapons as well.
All right, Mr. Rolfe.
Thank you, Your Honor. Regarding the non-monetary conditions, I've discussed them with Mr. Brownlee, and we would have no objection to those going forward at this time. Regarding the cash bond as proposed by the state, I would note that Mr. Brownlee is 51 years old. He's lived in Kenosha his entire life, as does the majority of his family. He has also been working for the last 4.5 years as a truck driver for Cisco. He does have some priors, but as noted by the state, those are all dated back to about the 2000 era. I'm also unaware of any failures to appear or any bail jumping charges in his past as well. Regarding the complaint itself, I would note that Mr. Brownlee does assert that he was defending himself in this case, and so I believe that there will need to be some investigation into the allegations going forward. So I can't speak exactly to the strength of the state's case at this time. For these reasons, we would ask for a reasonable cash bond. I do not believe Mr. Brownlee is a flight risk going forward. I believe he wishes to take the proper steps going forward and to be able to defend his case. and not to flee despite this. So we would again ask for a reasonable cash bond in this case. Thank you.
Thank you. All right, so in regards to the non-monetary issues,
Your Honor, I would just ask that if the Browns wish to speak, that the court have an opportunity to have them speak before the court renders any decision.
all right. Mr. Brown, Ms. Brown, I'm okay with you guys briefly addressing the court. I don't know if it's necessary at this point, given what I've read and given what I've seen and what I've heard here today. But I would give you a brief opportunity to make a statement if you'd like.
Yes. Yes, this is Mr. Brown.
Go ahead.
Yes. What this man has done has taken this mother from her kids. He didn't even be concerned with his own kids being there. This man is a monster. I think he should not even be considered for bail at all.
All right, thank you, sir. All right, so in regards to the non-monetary conditions, I would order that there be, if you do post bond and if you are released, Mr. Brownlee, there's to be no contact with the Brown family, any of the Brown family. That also goes for Sharnice's children. And Mr. Gravely, I will need that information in regards to the children's names and dates of birth for purposes of the bond. Not names, but their initials and their dates of birth for purposes of the bond. I would order that Mr. Brownlee not possess any weapons. And that is, of course, if he gets out. In regards to the setting of the bond, I know the bond has already been set at $1 million. I've listened to counsel's arguments in reference to the idea of protecting the public and a flight risk. You know, in looking at the incredible seriousness of these allegations and the facts that took place that are contained within the criminal complaint, there is in my opinion, there is a huge incentive for a flight risk here. I don't see what anybody would have to lose if they got out facing a charge like this. So I think when we look at a flight risk, I think looking at that charge, taking that into consideration is something that is very serious, especially these allegations. They're quite something. So I'm going to leave the bond at $1 million cash. I considered raising that after I read this, but I believe that's going to be sufficient to protect not only the community from this flight risk, but probably protect Mr. Brownlee as well, perhaps from himself. All right, so we're going to need a preliminary hearing, correct?
Yes, Your Honor.
What about March 16th at 9:30?
Do you have anything later in the week? Do you have anything that Friday?
Not without doubling stuff. We can do 8:15
On the, is it the 19th?
on Friday, the 19th.
That's my preference.
Mr. Rolfe, that'll work for you, sir?
I will not actually be representing Mr. Brownlee going forward, so at this time I can't speak to the exact.
Okay, that's fine. All right, and then Mr. Gravely, you'll get me those that information?
Yes, Commissioner, did you want me to say that orally, or do you want me to?
We could go ahead and put that, that way it's in the record.
Okay, so the initials of the 6 individuals are MLB, date of birth 9/24/09.
MLE.
KB, date of birth 12/27/13.
Okay, did you say KE or is B as in boy?
K twice, KKB.
KKB.
Yeah.
Thank you.
The next one is IYB. Date of birth 1/24/17. The next is AIB. Date of birth 1/5/16. The next is AJB. Date of birth 1/20/11. And then the last one is AAB, same date of birth as the previous, 1/20/11.
All right, thank you. All right, council, anything else?
Nothing else from the state.
Nothing on my side either, Your Honor.
All right, that'll be all for today. Thank you. Mr. Brown, thank you, sir.
All right, thank you.
Mr. Brown, if you have any questions, just contact the DA's office and we can talk.
All right, thank you very much.
Okay, all right. Take care.
I think he is.
Yeah, we got it.